My mother passed away in 2009. She left an RDP house to myself and my two brothers, one of whom has subsequently passed away. My surviving brother and his wife just sold the RDP house and they kept the money. What can I do to either reverse the sale or to get my money back? Cilna?
So that's an interesting one. Chris, the beginning of the question there, we can't see from the question whether the property was transferred in terms of the will yet. Right, we don't have that information. So I'm going to work from the assumption that it wasn't transferred. And the reason why I'm saying that is if the will indicated that the property was left to the viewer and the brother and it was transferred, you wouldn't have been able to sell the property and transfer it onto a third party without both owners' consent and signatures. And I mean, there's a massive process to get a property to transfer. So that wouldn't have happened. So what I'm thinking is that the brother sold the property while it was still owned by the deceased estate. And the only way that could have happened is if the executor, and now I'm assuming it might be the brother or somebody else that's close friends with the brother, if the executor of the estate gave transfer of the property. Now, the chances of an executor transferring a property, unless the will allows for that, is very unlikely and super improper. So the only way you can reverse a sale once it's been transferred is if you can prove that the transfer happened fraudulently. And from what I'm hearing, it could be, but I am obviously very, very careful on where I don't have the full facts to even use the word fraud in a sentence unless I know exactly what's going on. But my suggestion would be to go to the deeds office, and you will be able to know who gave transfer. And if it was a party that gave transfer fraudulently, definitely you can go to an attorney to commence proceedings to set the sale aside. But I need to caution the viewer on this. The chances of transfer taking place fraudulently, truly fraudulently, is really slim to none. The registrar of deeds is like the guy with the closest eye on things like this. You need to jump through 500.5 hoops to get to transfer. So it would be strange that transfer took place if it was in fact not done with the right parties, with the right authority to consent to the transfer. If, however, it was the case, you can definitely institute proceedings to set it aside. Once again, those proceedings will take, it's a long, painful process because you need to include, in this particular case, most likely the master of the court of the High Court as well. So you're going to have all the parties that's going to be affected, as well as the registrar of deeds and potentially the master. And to go through litigation like that is going to most likely be in the High Court, and it's going to cost obviously quite something, and it's going to be a long process. And when I say long, I mean a 2-3 year litigation. So just weigh up that before you institute proceedings. I think that's my Christmas gift to everybody. Is my advice on litigation is always to commence litigation. Always feels lekker, like you like taking control of something, and here we go. And the thing is, you get, I call it litigation fatigue, and I can see it in clients where litigation is drawn out. Not an eviction application. That's lekker, that's quick. Your files never even fade in color. They like lekker, 2 to 3 months, it's done. The tricky ones might take up to 8 months or so, but an eviction is quick and is over. But those long trials, really think about what it's going to do to you financially, but also emotionally, to go through proceedings like that. So yeah, I think you might have something if it was a fraudulent transaction, but just be careful to not jump into litigation, because once you're in, you can't just get out, and you need to push forward, and it could be expensive and massively emotionally draining.